Vice Chancellor Academic, Registrar, the Bursar, University Librarian, Provost of the College of Medicine, Provost of the Postgraduate College, the Dean of the Faculty of Law, Deans of other faculties and of students, Directors of institutes and centers, Heads of departments, distinguished guests, ladies and gentlemen. The 628th University of Ibadan Inaugural Lecture will be delivered today by Professor Omolade.O.Olomola on behalf of the Faculty of Law. Professor Omolade.O.Olomola was born on 22 April 1972 at Catholic Hospital Lawore family of Aquinos Compound, Iditi, in Oyo State. Both parents are fondly remembered. Professor Omolade.O.Olomola commenced her formal education at the Polytechnic Staff School in Jokodo, Ibadan between 1975 and 1983, and proceeded to the Federal Government Girls College of Winnie Hills, Oyo, between 1983 and 1989. She gained admission into the Faculty of Law of this university in 1991-1992 academic session and graduated with a Bachelor's of Law Honors degree LLB in 1997. She attended the Nigerian Law School Abuja and used the Abuja Pioneer Set and was subsequently called to the Nigerian Bar in September 1999 as a barrister and solicitor of the Supreme Court of Nigeria. Driven by a strong passion for academia, she returned to the University of Ibadan, where she obtained a Master's in Law degree LLM in the 2001-2002 session, being among the pioneer cohort of postgraduate law students. Subsequently earned a PhD in law from the University of Ibadan 2013, specializing in family law and gender justice with clinical legal education. It is noteworthy to state that she was among the first set of doctoral graduates produced by the Faculty of Law in 2013, becoming the first full alumnus of the Faculty of Law of this university to earn all her academic degrees from undergraduate to doctoral level at the University of Ibadan. During her National Youth Service Corps year, she worked as a research assistant and counsel in the chambers of Yemi Akisheye George and Co. Shobande Avenue or Remejiba. She later practiced briefly with the Chief Lado Shubadako, SAN and Co. Onija Ibadan, Emmanuel Abiodo and Co. Onireke Ibadan, and eventually as head of chambers at Chief Mrs. Phoebe C. Ajayobe, SAN and Co. in Jericho, Ibadan. Thereafter, she transitioned fully into academia in 2001, teaching at Ambrose Ali University, Ibadan Studies Center, and later at the Leeds City University in Ibadan. Professor Omolade.O.Olomola was appointed lecturer grade 1 in the Department of Private and Business Law of this university on 21 March 2007. He rose through the ranks to become a professor on 1 October 2021. Following the inauguration of the newly created Department of Private and Property Law, University of Ibadan, by the University Management in February 2015, Professor Olomola was appointed as the pioneer acting head of department. She handled the affairs of the office till July 2017. He is presently the first substantive head of department. Professor Olomola stands out as a distinguished legal educator and legal clinician, and she is currently the alternate director of the Women's Law Clinic in the Faculty of Law of this university. In 2009, she was awarded the prestigious MacArthur Foundation grant, which she utilized at the University of Toronto in Canada under the International Reproductive and Sexual Health Law and Rights Program. This research experience significantly influenced curriculum development at the University of Ibadan, culminating in the introduction of reproductive and sexual health law and rights in the LLB program of this university. Her area of specialization include family law and social justice, gender justice, child justice, clinical legal education, reproductive health rights law, international humanitarian law, and international human rights law. She edited Family Law and Succession in Nigeria in 2021, and also co-authored Gender-Based Violence Law and African Society that is published in the United States in 2023. She also contributed to clinical legal education in Nigeria and also in India. The textbook was published in India in December 2025. She has authored over 60 scholarly publications in both national and international outlets and has delivered more than 30 technical papers at conferences, workshops, and seminars. She has also served as legal consultant on several internationally funded projects, including the ICARE Nigeria Adolescent HIV Project, funded by the National Institute of Health and Human Development of the United States, and the Arise and Win projects of Women Resilience, funded by the International Development Research Center, IDRC, in Canada. She has contributed to clinical legal education initiatives in both Nigeria and Uganda. Additionally, she is a faculty member of the Center for Child and Adolescent Mental Health, the University College Hospital Ibadan, where she teaches in the MSc Child and Adolescent Mental Health Program. Professor Olomola has also rendered services to the University of Ibadan. Her roles have included examination coordinator in the Department of Private and Business Law between 2007 and 2008, sub-dean undergraduate between 2008 and 2009, and membership of several Senate committees, including curriculum, general studies, and admissions. She has also served on the faculty board of arts and is currently a member of the Senate Curriculum Committee. He has also contributed to institutional governance through roles such as convener of the University of Ibadan Sexual Harassment Review Committee in 2025, co-convener of the Gender Policy Review Committee also in 2025, and a member of the University Ethics Policy Framework. She is the chairperson of the African Research Security Consortium Committee, University of Ibadan branch, 2000 from 2025 to date. She is also a member of the Anti-Corruption and Transparency Unit, active under the Office of the Vice Chancellor. Beyond the University of Ibadan, Professor Olomola has made significant contributions to legal education and professional development. She served as the acting Dean of Law at Elizade University in Aramoki between 2017 and 2019, where she pioneered Elizade University Law Journal. She also served as the Dean of Law at Cavendish University in Uganda between 2022 and 2024 under the Nigerian Technical Aid Course Scheme. During her tenure, she established the Cavendish University Law Journal and co-founded the Cavendish University Law Clinic, advancing experiential legal education. Professor Olomola currently serves as subcommittee chairperson of the Nigerian Bar Association section on legal practice, on family law, succession and estate planning. She previously served as the deputy head of the Nigerian Bar Association Women Forum Welfare Committee between 2021 and 2024, and she is currently the head of the Research and Documentation Committee. Professor Olomola is a member of several professional bodies, including the Nigerian Bar Association, the Nigerian Association of Law Teachers, International Federation of Women Lawyers, Global Alliance for Justice Education, Network of University Legal Aid Institutions, and the Society for International Humanitarian Law Teachers. He is a visiting professor at Providence University in Uganda, and she also supervises dissertation from the University of South Africa, UNISA. Professor Olomola has supervised over 150 undergraduate law essays and has an expert and extensive record of postgraduate supervision. She has supervised numerous undergraduate projects and over 60 postgraduate dissertations, produced 6 PhD graduates, and is currently supervising 5 doctoral candidates. Clap for her properly. In recognition of her excellence in teaching, she was named one of the outstanding lecturers of the year at the Southwest Nigerian Excellence Award, in 2022. Professor Omolade.O.Olomola is happily married to Akindele Olomola Esquire, a notary public, and they are blessed with Caris Munisola Oluwa and Christian Oluwa Folahon. Distinguished ladies and gentlemen, and I invite Professor Omolade.O.Olomola to deliver her lecture, which is titled Gender Justice and Intersectionality of Family Law Life. Professor Olomola.
The Vice Chancellor, Deputy Vice Chancellor Administration, Deputy Vice Chancellor Academic, Deputy Vice Chancellor Research, Innovation and Strategic Partnerships, Registrar, Bursar, University Librarian, Provost of the College of Medicine and the Postgraduate College, Dean of the Faculty of Law, Deans of other faculties and of the students, Directors of Institutes and Centers, and with kind permission of the Vice Chancellor, my noble lords, here present and learned seal, distinguished ladies and gentlemen. I give all the glory to God on my journey for this honor for such a time as this in the history of the Faculty of Law. It is indeed a great opportunity to be nominated to deliver the 628th inaugural lecture on behalf of the faculty, coming exactly 40 years after the first one was delivered by the Foundation Dean, Professor Folani Shillong, in 1986. I thank the Dean of Law for this nomination and also appreciate all who decided to grace this occasion with their physical presence or virtual presence. Today's lecture is the third in the Department of Private and Property Law, and with all modesty and humility, 5 years after my elevation to the position of professor in the premier university. It is worthy of note that by the grace of God, I am the first full-bred alumnus of the Faculty of Law, University of Ibadan, delivering an inaugural lecture on behalf of the Department of Private and Property Law. I am also privileged to have 2 of my teachers on the stage, the Deputy Vice Chancellor Reese and the Dean of Law, Professor J.O.A. Akitayo. Vice Chancellor, sir. My lecture title, Gender Justice and Intersectionality of Family Law Lifelines, is a summation or aggregate of my scholarly pursuits in the field of family law, gender rights and justice, and clinical legal education. My background. My adventure into the world of family law began with my teacher, the incumbent Vice Chancellor of Babalola University at Ekiti, Professor Smaranda Olaribe. She introduced me to the rudiments of what has become a life and a passion for me over the last 25 years. I want to specially recognize my Gamaliel, a mentor par excellence, Professor E.M.C. Bankoshe, Senior Advocate of Nigeria, the program Deputy Vice Chancellor raised, who is my forebearer in the field of gender, and who through her teaching and mentoring style poured herself sufficiently into me. She and other predecessors in the field of gender consolidated my interest, which has blossomed. Thus, and of his fullness have we all received grace upon grace. My academic journey. My academic journey started from the nursery and kindergarten section of Polytechnic Staff School Ibadan with my first teacher, Mrs. C.M. Ojeshino, and from there to Federal Government Girls College, Oyo in 1983, where I was taught with the second set of the 6334 Educational Policy of the Federal Government. My set eventually wrote to WAEC in October and November 1989. Because of the adjustment of the calendar immediately after my set, the Federal Government reverted to the regular May June examination. When I gained admission to study law at the University of Ibadan, I was among the second set of the 5-year program. And I need to say that I was privileged to be among the very first set of Masters of Law class of 2001-2002 in the faculty. And the same feat was recorded by the mercies of God when I convoked among the first 3 to earn a PhD in law in 2013, completing the full cycle of the full-bred alumnus. Studying law came naturally because my late dad wanted to be a lawyer. He, in fact, had gained admission to study law with the first set at the University of Ibadan, now Inaugural University, Ile-Ife, which was then situated at the Polytechnic Ibadan campus. Unfortunately, he couldn't complete the program because the university had to move to Ile-Ife. And as a family man, he could not combine full-time academics with full-time career. The rest, they say, is history. My trajectory. Why gender justice? What is the nexus between family law and gender justice? My trajectory to the foray of gender justice actually predates the answers I discovered through family law. My LLB long essay titled Proprietary Right of Females Over Family Property established the challenge faced by the female gender with respect to family property, whilst my LLM master's dissertation accentuated the harmful traditional practices against women in Nigeria, Ghana, and India. In the course of my doctoral research, I noted the fallacy that most times people take gender for female. On the contrary, gender is not female specific. Rather, it is a social construct for male and female. I discovered that isolating men from the gender discourse is a major drawback because the desired balance will never be achieved in this wise. And I will begin by discussing the key words and concepts in this lecture: the contract of marriage, dissolution, and matrimonial causes in Nigeria. The family is the smallest unit of the society and considered the basis of human community and nucleus of the society. There is no precise definition, but it can be described with wide connotation, which includes all persons with common ancestors, and restricted connotation with a smaller group of husband, wife or wives, the children and dependents. Black's Law Dictionary defines family to include a group consisting of parents and their children, a group of persons connected by blood, by affinity or by law, and a group of persons usually relations who live together. A just and coherent family law system is therefore fundamental to national development, gender equality, and social cohesion. Family law. This aspect of lecture examines the constituents of family law in Nigeria, their operation, the tensions among statutory, customary, and Islamic legal systems, and reform needed to strengthen the family as a foundational social institution. Nigeria's plural legal system shares family relations, reflecting its history. Colonization and religion influenced marriage and family life, with elites preferring statutory marriage over customary and Islamic ties. Strictly speaking, there are only 2 types of legally recognized marriages celebrated in Nigeria, and they are customary law marriage, which includes Islamic law marriage under Section 2 of the High Court Law of Northern Nigeria 1963, and marriage contracted under the Marriage Act, Cap M6, Laws of Federation 2004 as amended. This pluralism of marriage laws and the dichotomy of courts results in various kinds of internal conflicts, which were compounded by the fact that a person married under more than one system at the same time, or might have converted one type of marriage to another type of marriage under certain circumstances. Vice Chancellor, sir. As important as this aspect of the law is to human existence, family law is still an elective course as prescribed by BMAS and lately CCMAS. Yet, matrimonial courses form part of the syllabus taught at the Nigerian Law School till date. Indeed, this is an irony that denies the reality and undeniable fact of existence. Milestones of marriage laws in Nigeria. Nigeria's statutory marriage laws evolved from the colonial era, ordinances beginning in 1863, through territorial extensions and legislative reforms, culminating in the current Marriage Act Cap M6, which continues to regulate statutory marriages. Statutory marriages are governed by the Marriage Act and the Matrimonial Causes Act, with Section 3 of Marriage Validation Act of 71 validating only intended statutory marriages, while the Constitution vests legislative authority over such marriages exclusively in the National Assembly. Vice Chancellor, sir, this is another challenge. Arrogating and giving the totality of power to the National Assembly alone for a subject as important as marriage is an injustice. It is important to state at this juncture that when marriages fail, the state high court assumes jurisdiction to the exclusion of federal high court. This is a matter of concern and calls for attention. The classical definition of marriage. The classical definition of marriage in English law is that of the dependence in the case of hide and hide, and it states as follows. I concede that marriage as understood in Christendom may be defined as a voluntary union for life of one man, one woman to the exclusion of all others. This definition involves 4 conditions. The marriage must be voluntary, it must be for life, it must be heterosexual, and the marriage must be monogamous. This definition, which is still in force in Nigeria, has completely obliterated the idea or practice of same-sex marriage in Nigeria. Marriage as a contract. Marriage is a special contract and not a mere contract, but the one that creates status as it was decided in the celebrated case of past Bender and Attorney General. In Oloba and Nakereja, the Supreme Court of Nigeria defines status as follows. The status of an individual in legal terms is the legal position of that individual in or with regard to the rest of the community. First, marriage is a status. And the court further stated that marriage is a status and a decree dissolving marriage is a judgment upon status. Family status therefore refers to the standing or rank of a person within the family. A person domiciled in Nigeria has the capacity to marry only if the following conditions are fulfilled. Number 1, parties to a marriage contract must have the single status at the time of marriage. 2, both parties must have capacity which is over 21 years based on common law contractual marriage, but the Child Act has stipulated 18 years. Parties must not be within the degree of consanguinity and affinity, and these prohibited degrees are listed in 1st schedule of the MCA 2004. 4, the consent of the parties. 5, they must be opposite sex. Formalities of a valid statutory marriage. Notice of marriage filed at the marriage registry to be displayed publicly. Issuance of registrar certificate by the registrar. Special license can be issued in place of notice. Caveats may also be entered to forbid the issuance of certificates. Celebration of marriage. Celebration of marriage in the registrar's office. Celebration of marriage in a licensed place of worship in presence of at least 2 witnesses. Celebration of marriage in the diplomatic mission provided one party is a Nigerian citizen and the marriage is conducted before a qualifying diplomatic or consular officer. Customary law marriage in Nigeria. Customary and Islamic marriages are generally less formal than statutory marriage. Nigerian law currently recognizes only customary and statutory marriage outside Muslim rights, Chukuma and Chukuma. Nigeria's Court Ordinance 1914, which gave statutory recognition to indigenous marriage laws and customs, while also providing for the application of marriage laws. Customary law is the oldest source of Nigerian law, existing before British colonization. It is not enacted by any legislature, but it is enforceable and binding within Nigeria. It regulates relationships, especially in personal law areas like marriage, succession, and property rights. Obaseki J.S.C. describe customary law as the organic and living law of an indigenous people of Nigeria, regulating their lives and transactions. It is organic in that it is not static. It is regulatory in that it controls the lives and transactions of the community subject to it. Oyewumi and Nigeria, 1990. Customary law is a mirror of accepted usage, and it is derived from the indigenous norms, practices, and cultural values. Customary family law varies considerably across ethnic groups, reflecting the diversity of Nigerian society. And yet, in his book of customary law, defines customary law marriage as a voluntary union of one man and woman or women to the exclusion of all others. Though there are variations from one ethnic group to the other, but even within the same tribe, there are variations. It is potentially polygynous, allowing a man to marry a limited number of wives, and this distinguishes it from Islamic marriage. These three systems complement one another, but sometimes conflicts with one another, creating complex jurisprudential and human rights challenges. Essential requirements of customary marriage. Omolade JCA, Nisiri and Nisiri. listed the requirements for a valid customary marriage as follows. The parties must possess capacity, there must be payment of dowry or bride price, and there must be a ceremony of marriage and the handing over of the woman to the man's family. The unwritten nature of customary marriages and the lack of documentary evidence has created significant challenges related to proof of marriage and determination of its validity. Islamic law marriage. In Islam, marriage is a sacred and highly encouraged institution ordained by Almighty Allah to promote companionship, family life, vocation, and moral conduct. The Holy Prophet, peace be upon him, stated, "There is no celibacy in Islam." Furthermore, he prescribed by saying, "All you young men, whoever is able to marry should marry, for that will help him lower his gaze and guard his modesty." Al-Bukhari. Under Islamic law, marriage nikah is both a contract and a strong covenant, mitakan galiza, that creates mutual rights and obligations between a man and a woman. The importance of marriage is emphasized in the following hadith: "Marriage is my sunnah, and whoever keeps away from it is not from me." In Nigeria, the Maliki school of Islamic law is the most widely recognized and traditionally accords the husband a leading role within the family. A valid Islamic marriage nikah requires the presence of a guardian, wali, a clear offer or proposal, ijab, an acceptance, kabul, 2 witnesses, and the payment of dowry, mar. Consent of bride and groom is essential, and the marriage must be publicized. The Holy Quran lays down the permanently prohibited degree of marriage. Regarded as a solemn covenant nikah, marriage is both a legal and spiritual institution in Islam, serving as a means of companionship, emotional and sexual fulfillment, procreation, and an act of worship or ibadah. Ambali 2003. Polygyny and Islam. Polygyny, which is the practice of having more than one wife at a time, is permissible in Islam. In Islam, a man is restricted to marry only 4 wives at a time, and the Quranic verse that permits polygyny reads thus: "And if you fear you shall not be able to deal justly with orphan girls, then marry other women of your choice, 2 or 3 or 4. But if you fear you shall not be able to deal justly with them, then only one." Surah to Al-Nisa, verse 3. Contemporary Muslim family law reforms focus on addressing gender inequalities in marriage and divorce, particularly concerning child marriage, unilateral divorce, talaq, and polygyny. While these issues remain controversial, many Muslim majority countries have introduced reforms by adopting diverse juristic opinions, including setting minimum marriage ages, thereby modernizing aspects of classical Sharia while retaining its core principle. The registration of Islamic marriages adopted in many Muslim majority countries promotes legal certainty, accountability, and responsible polygyny by requiring formal documentation, and in some jurisdictions imposing sanction for non-registration. Countries like Algeria, Bangladesh, Egypt, Gambia, Indonesia, Iran, Malaysia, Morocco, Pakistan, Philippines, Senegal, Sudan, Tunisia, and Turkey prescribe sanctions for failure of registration. And failure to ensure this equality makes polygyny forbidden and haram. The primary conditions, including financial ability to support multiple households, and often difficult capacity to maintain emotional and physical fairness. The absence of legal sanction in Nigeria for irresponsible polygyny has contributed to indiscriminate polygynous practices by some men, often contrary to Islamic injunctions with harmful consequences for the entire family. Vice Chancellor, sir. In view of the prevailing global dynamics, there should be a well-defined age before a party can contract a marriage under any system of law. This will reduce the practice of child marriage in every part of the world. This injunction further stresses the need for the mandatory general registration of all types of marriages practiced in Nigeria. Dissolution of marriages in Nigeria. A matrimonial court is a legal proceeding for the dissolution of marriage, including appeals arising therefrom. Under the MCA, divorce is based on the principle that the marriage has broken down irretrievably, rather than on matrimonial offences, and at least one of statutory grounds must be established under Section 15, subsection A to H MCA. The court may grant leave to file for divorce within 2 years of marriage, where refusal will cause exceptional hardship or the respondent has shown exceptional depravity. The 2-year rule is to deter people from rushing into and out of ill-advised marriages, and that dissolution of marriage should not be unduly for sale. and spouses should be afforded a reasonable period to test the validity of their union. Section 15A to H and Section 16 of the MCA. By Section 16.2, the court hearing the petition is enjoined to hold that the marriage has broken down irretrievably if the petitioner establishes one or more of the following facts: that, number one, willful and persistent refusal to consummate, intolerable adultery, intolerable conduct, continuous desertion of at least 1 year preceding the petition, 2 years separation and the respondent does not object to a decree being granted, 3 years continuous separation, failure to comply with a decree of restriction of conjugal rights made under the MCA for not less than 1 year, presumption of death from prolonged absence, bars to dissolution of marriage. A petitioner who has come to the satisfaction of the court that the marriage has broken down irretrievably is entitled to a decree of divorce, and that such decree may be refused if an absolute or discretionary bar applies to the case. The absolute bars are condonation, connivance, and collusion. On proof of absolute bar, the court is bound to dismiss the petition. The discretionary bars are petitioner's adultery, desertion, and conduct conducive to the commission of matrimonial offence. A decree of dissolution of marriage is granted in 2 stages. A decree nisi, followed by the expiration of 3 months by decree absolute. Custody of children and maintenance under the statute. In Nigeria's custody proceedings, child's best interest is the court's paramount consideration, and possible others may include sole custody to one parent with access to the other, custody to a third party if neither parent is fit, joint custody with care and control to one parent or both. Others can be enforced through attachment, committal for content, or risk of sequestration. The Act allows court to make maintenance orders for spouses or children considering the means of the party, any capacity, conduct of the parties, other relevant factors which include standard of living and financial needs. And there are generally 2 types of maintenance: maintenance in general and maintenance pending determination of the proceedings. Dissolution of customary marriage. Vice Chancellor, sir. The Act defines marriage to include a purported marriage that is void, but it does not include the one entered into according to Islamic rights or customary law. The customary rules of dissolution of marriage are not as developed and stringent as the case of statutory marriages. The family plays a major role in the formation and dissolution of customary law marriage. First, a customary law marriage may be dissolved by judicial mode, non-judicial mode, and by death. Grounds for dissolution of customary marriage. Under customary law, the divorce is based on customary grounds which include adultery, cruelty, desertion, immorality, laziness, sterility, witchcraft, impotence, failure to maintain a wife, non-payment of bride price, and theft. Fathers traditionally have exclusive custodial rights over children, while mothers have limited or no corresponding custodial rights. Customary law has historically reflected gender inequality, granting men greater marital privileges and imposing stricter standards of fidelity and conduct on women. This illustrates entrenched patriarchal norms and unequal marital rights. Vice Chancellor, sir. Gender inequality pervades customary law marriage in Nigeria. Talaq. The Arabic word for divorce or dissolution of marriage is talaq. Literally, it means loosening a knot. Technically, however, it means breaking the marriage bond. In Islamic jurisprudence, marriage nikah is conceived as a permanent union designed to foster mutual tranquility, sukun, affection, mawadda, and compassion, rahman, enabling the spouses to establish a family unit and raise children within a secure moral framework. Although Islam gives the right of divorce to both husband and wife, it should not be done for trivial reasons. According to a Hadith, Sunnah, Abi Dawud, Kitab al-Talaq, Hadith number 2178. The Holy Prophet, peace be unto him, was reported to have said, with Allah, the most hateful of all things permitted is divorce. The most common form of talaq is husband's repudiation, which may be revocable talaq rajai or irrevocable talaq baini, depending on how it is pronounced. Triple talaq, talaq al-talaq, is traditionally regarded as classical Islamic law as producing an immediate and final dissolution of the marriage. Grounds for dissolution of marriage under Islamic law. 1. Long absence without knowing the whereabouts of the husband. Long imprisonment. Captivity by war enemies. refusal to provide for the wife, impotence, other grounds which include unfaithful or defiantly inattentive to our religious duty to dissolve the marriage on these grounds, maltreatment and insanity. Steps before talaq. If you fear a break between two, appoint two arbiters, one from his family and the other from ours. If they wish for peace, Allah will bring about their reconciliation. For Allah has full knowledge and is acquainted with all things. Surah Al-Nisa, chapter 4, verse 55. If divorce is still necessary, the Quran insists that it should be done with kindness and without dishonor. Types of talaq. Talaq rajal, which is revocable divorce. Talaq baini, irrevocable divorce. Divorce at the instant of the wife. First, divorce by court order. Mubarrah, divorce by mutual agreement of husband and wife. Under Islamic law, the father is responsible for maintaining his children, including those born within the prescribed period after divorce. And generally, a wife is not entitled to maintenance except during the Iddah period. Right to marry. The right to marry and form a family is fundamental human rights under Article 16 of the Universal Declaration of Human Rights 1948 and is covered by ICCPR 1966, and it guarantees the following: men and women have equal rights in marriage and dissolution. Free and full consent of both parties are required. Family is the basic unit of the society entitled to protection. There must be no restriction based on race, nationality, or religion. Family life dynamics are taking convolutions in contemporary society. Family law is evolving rapidly due to social values, technological advances, and emerging issues such as redefinition of marriage and child custody. Olomola 2021. Vice Chancellor, sir. It is evident from the above that definition of marriage and family, as well as the core principles that guide the sanctity of marriage and family, has been redefined and is still being redefined in various issues, coming to light as the conflict between what is right and acceptable in the society ensues. Recent developments in family law. ART have transformed family formation and includes methods such as artificial insemination, in vitro fertilization, surrogacy, gamete intrafallopian transfer, zygote intrafallopian transfer, and intracytoplasmic sperm injection. Surrogacy involves a woman carrying a pregnancy on behalf of another person or couple under a contractual arrangement. These technologies challenge the traditional concepts of family and reproduction and have led to increasing legal disputes. ART raise ethical, moral, medical, and legal concerns, including risk of human error and potential harm to children. Critics argue that ART interferes with natural procreation, while the Roman Catholic Church opposes methods that separate procreation from the sexual union. The handling of surplus IVF embryos through disposal, research, storage, or donation creates complex ethical and legal challenges. Nigeria lacks a comprehensive legal framework for ART. Although the proposed Nigerian Surrogacy Bill 2024 represents a significant step towards regulating surrogacy and protecting the rights of all parties involved. The proposed Nigerian Reproduction Authority Establishment Bill was not enacted, leaving significant legislative and regulatory gaps and highlighting the need for legislative reform. The National Health Act 2014 addresses certain aspects of reproductive health. It does not comprehensively regulate assisted reproduction. The celebration of double-deck marriage. At this juncture, it is important to discuss this ambiguity that has been created by long-term practice of double-deck marriage in Nigeria. It is common practice in Nigeria for couples intending to marry under the Marriage Act to first contract a customary marriage before solemnizing a statutory marriage. A practice recognized and validated by the Act, which permits the same couple to celebrate a customary marriage followed by statutory marriage. The question is, will both marriage coexist? Does the second marriage under the Act convert the customary law marriage, which is potentially polygynous, to a monogamous marriage? There is no statutory provision to this that the latter extinguishes the former. Vice Chancellor, sir, this is a conundrum, an ambiguity created by multiplicity of marriage systems and presenting one as superior to the other. From gender equality to gender justice. Vice Chancellor, sir. Family law is important for a sane society, especially given the rampant reality of dysfunctional families. The present system is plagued by different levels of injustice. Some challenges are religious, some from personal desires, and others from societal prescription of stereotypes. Gender equity, gender equality, and gender justice are distinct but interconnected concepts, presenting progressive stages towards fairness and inclusion. Equality provides the same opportunity to everyone. Equity provides support to individual needs. And justice removes systemic barriers that prevent equal participation. In many patriarchal societies, sons are valued more than the daughters, leading to gender bias and discrimination from birth, as reflected in cultural attitudes and traditional practices. The sex differentiation is evident from the moment of birth, when the child is first identified as a male or female, especially in patriarchal society where the birth of a son is a particular cause for celebration. The baby boy is always dancing, and the baby girl is just a girl. In the absence of sons, the birth of a girl is oftentimes a cause of lamentation, as typified in an ancient folk song which says, "Why do you call no girl when we wish for a boy? Take the jar, fill it from the sea, may you fall into it and drown." Can you imagine? In the course of Charlie children, the emotional, sexual, and psychological stereotyping of females begin when the doctor says it's a girl. Some preference becomes human rights issue when it results in discrimination and gender inequality. Promoting gender equality is a fundamental objective of international human rights law. Since 1970s, gender studies have developed as an interdisciplinary field, examining how social and institutional structure create and reinforce gender roles and power inequality. Under gender equality, everyone has the same rights, opportunities, and resources. Essentially, equality is concerned with giving everyone the same pair of shoes, irrespective of the sizes. Whereas gender equity differs from equality by recognizing that women may have different needs and starting points, requiring fair tailored measures to address historical disadvantages and achieve genuine equality. Essentially, equity is concerned with giving everyone a shoe that fits. Gender justice is an intersectional and transformative framework that seeks to dismantle structural discrimination and unequal power relations to ensure the full and substantive enjoyment of rights by women and other gender marginalized groups. Gender justice. Gender justice is a holistic approach, promoting equal rights and opportunity, removing systemic barriers like sexism, racism, and classism. It is essential for advancing women and girls' rights and achieving gender equality, especially in Nigeria, where patriarchal norms shape family law. The tension between equity and equality in Nigerian family law is evident in discriminatory citizenship, inheritance, and divorce laws, where equity-based reforms seek to address women's historical and economic disadvantages despite persistence of legal inequalities. Nigeria has ratified CEDAW, but enforcement is weak. Olomola 2008. Gender equality, equity, and justice in family law. Gender equality, equity, and justice represent progressively broader approaches to addressing discrimination in family law, with Nigerian courts increasingly advancing substantive gender justice by invalidating discriminatory customary practices and promoting women's equal rights despite challenges of a plural legal system. In Ukeja and Ukeje, the Supreme Court held that excluding female children from inheritance under the customary law was unconstitutional. In Anekwe and Iweke, the court invalidated customs denying widows inheritance rights, condemning them as discriminatory and incompatible with justice and equity. The lead judgment describes such customs as punitive, uncivilized, and are not intended to protect the selfish perpetration of male dominance, aimed at suppressing the rights of women in a given society. Per Onoge JSC as it then was. This decision reflects a judicial shift from formal equality to towards substantive gender justice by challenging patriarchal customary practices. Vice Chancellor, sir. The nagging question since then has been, why has the application of a universal plethora of rights failed to achieve the much desired equal status to everybody, most especially women in the society? The answer to this question has been because of the feminist movement. Feminists argue that gender-neutral or gender-blind laws often fail to address the distinct experiences and needs of women, resulting in systemic bias. They advocate for gender mainstreaming and gender-sensitive approaches to ensure that the rights and needs of women and girls and other vulnerable groups are effectively protected. Feminist scholars also contend that the traditional language of rights is often individualistic and inadequate to capture the lived realities of women's experiences. An intersectional feminist approach reveals how overlapping identities compound gender injustice. The concept of intersectionality. Intersectionality, developed by Kimberly Crenshaw in 1989, is a framework that explains how overlapping identities such as gender, race, class, ethnicity, disability, religion, age, and sexual orientation shape individuals' experiences of discrimination and privilege. Originating from Black feminist scholarship, it highlights the Black systems of inequality that are interconnected and demonstrated that Black women's experiences cannot be understood by considering race or gender in isolation. Today, intersectionality is widely used as a theoretical and practical tool for analyzing multiple forms of inequality. Vice Chancellor, sir, at this juncture, it is important to discuss the nexus between feminist jurisprudential schools and the concept of gender discrimination and gender justice. Liberal feminist jurisprudence advocates formal legal equality to eliminate gender discrimination, to eliminate gender discrimination, but its limitation in addressing structural inequality are evident despite constitutional protection and judicial decisions like Ukeja and Ukeji. Radical feminist jurisprudence contends that achieving gender justice requires transforming patriarchal legal and social structures, as formal equality alone cannot eliminate systemic gender discrimination. Cultural feminist jurisprudence, influenced by Carol Gilligan, argues that gender discrimination stems from the law's devaluation of women's caregiving and relational role, exposing the limitations of formally neutral legal standards in family law. Socialist feminist jurisprudence views gender discrimination as a product of both patriarchy and economic inequality, advocating legal and economic reforms to secure women's equal access to property, resources, and justice. Postmodern feminism and critique of womanhood. Postmodern feminist jurisprudence influenced by Julie Butler views gender as socially constructed and emphasizes that gender discrimination is shaped by intersecting identities and social conditions requiring an intersectional approach to achieving justice. African feminist jurisprudence advocates a culturally grounded and transformative approach to gender justice. The application of intersectionality to family law includes the following: in marriage and divorce, custody and parental rights, inheritance and property rights, child support, domestic violence, paternity issues, and reproductive rights. Summarily, intersectionality ensures that gender justice in family law is not one size fits all, but responsive to the diverse realities of women and families. Conclusion. Vice Chancellor, sir. To conclude, I quote Mahatma Gandhi: "Peace will not come out of the clash of arms, but out of justice lived and done by unarmed nations in the face of odds. We are the ones responsible for our world. Change from us can ultimately change our society for the better. We must advocate to the people about equality, equity, and justice. A more meaningful focus on gender justice can be achieved with intersectionality. Gender justice means ensuring women have equal rights, opportunities, and protection within the law, especially within the family. Family law becomes a lifeline because it directly governs marriage, custody, inheritance, divorce, and maintenance in areas where inequality is mostly felt. Through an awareness of intersectionality, we can better acknowledge and ground the differences amongst us. Recommendation. Vice Chancellor, sir. Why are we not living our reality? family law is crucial as it governs the creation, regulation, and duration of family relationships, protecting individual rights and welfare. And based on the above issues and other issues based in this lecture, I recommend the following. Curriculum reform, making family law a compulsory course for law students. Legislative reform, adopting intersectional approach to family law in addressing multiple forms of discrimination. And other than having a single marriage law, strengthening legal pluralism through legislation of all marriages, harmonize traditional marriage acts, codify Islamic marriage acts, civil marriage acts, Christian marriage acts, and divorce reform acts. Review of the Child Rights Act to enhance gender sensitivity for girls, and review of the BAP Act to strengthen responses to domestic violence, including male victims. Procedural reform and capacity building to train lawyers and judges to apply intersectional reasoning, enabling decisions that move beyond one-size-fits-all approaches, and better reflect the lived experiences of litigants, and so that the poor would have hope and injustice will shut our mouth. Acknowledgements. Vice Chancellor, sir, can you permit me to acknowledge all you have contributed to this milestone? And as analytic goes, only a couple give birth to a child, but thousands keep watch over the child. And it is with profound gratitude and humility that I stand before you to deliver this lecture today. First and foremost, I give glory to my Lord Jesus Christ, in whom I live and move and have my being. My victory is in your blood, my confidence is in your name. You took the shame so I can shine. So much you did without surprise. Thank you, the Lord of my journey. I wish to express my sincere appreciation to the University of Ibadan and the Faculty of Law for a nurturing environment for scholarship, research, and professional growth. I acknowledge the support of the university management, including Professor Inaugural, the third Vice Chancellor of this university, Professor Adigun Agbaje, former Deputy Vice Chancellor Academics, Professor Rotimi Olenide, and particularly grateful to the current Vice Chancellor, Professor Kayode Adebo-Alende, SFSSP, MNI, and the Dean of Faculty of Law, Professor J.O. Yakitayo, for their leadership support and for this nomination. I deeply appreciate my academic mentors and supervisors who laid the foundation for my scholarly journey. My non-research supervisor, Professor G.G. Oke, blessed memory, my dissertation supervisor, Professor Esperanza Olamide, and my thesis supervisor, Professor Liebisi Bambushe Sene. I profoundly honor her as a mentor by excellence, whose guidance and encouragement have shaped my academic trajectory. I remember with gratitude Honorable Justice Bambushe of blessed memory for his tutelage and kind support. I extend heartfelt appreciation to my teachers from kindergarten to date, especially Mrs. Okebukola, here seated, but she was my body house mistress when I was at General College. I appreciate Professor Yemi Akishayeji, Advocate of Nigeria, who entrusted me my first research assignment. Professor Justice Olo, who inspired my interest in human rights and justice. I appreciate my colleagues in the faculty. I appreciate all my senior colleagues and my other colleagues, and particularly Department of Private and Property Law. I appreciate Nakato Foundation, OWSD here present today, NBA, NDAWF, NDASI, the Oke Clan of Abeokuta and Lagos, the Ola family, Bankodemo family, Lawere family, Kende family, Ipadiola family, the Oguniepa family, and the Ojo family. I deeply appreciate my in-laws, especially my mom-in-law here seated, Mrs. Beatrice Olimola, and the entire Olomola family of Ikoti Lesha. I thank all the family, Bagebo family for their warmth and love. I appreciate my sister-in-law, Dr. Shola Olomola of the research firm, Prince Adebayo Shijuade, Prince Adekunle Omonini, for all my research travels and for all my travels and research. I'm immensely grateful to my siblings, Professor Dr. Omolara Arewa and family, Dr. Omolola Arewa and family, Engineer Omolade Oke and family, Mr. Omolade Oke and family, Mr. Otoye Oke and family, who came all the way from United Kingdom to be here today. Thank you very much. I acknowledge my cousins, Mr. Adedoyanini, Mr. Adedoyanini, may God preserve us all. I acknowledge my church family, Shepherd's House of Way Family Church, Abeokuta Class 1, Holy Trinity African Church Translation, and IBCUAF, Maranatha, for their spiritual support. I owe a profound debt of gratitude to my children, my learned friends, Karis Monisola Olomola Esquire, and Christian Olomola for their understanding, patience, and encouragement. To my dear husband, Akidele Oladapo Olufemi, my greatest cheerleader, encourager, friend, and partner in life. Thank you for your steadfast support throughout this journey. Your encouragement sustained me through the rigors of academic life, and for this I'm deeply grateful. I love you dearly. To Elroy, the God who sees me, and Ebenezer, my stone of help. More than my mouth can testify, more than my mind can comprehend. I've seen the wonders of your grace, and I'm so sure this is not the end. See how far you have brought me. I'm worthy. I can see, I can tell, and I know it's your grace. All my days I will sing your praise. My heart is full of gratitude to you and no one else. Thank you, Lord Jesus. I'm only here by your grace. Thank you, Jesus, for not giving up on me. Vice Chancellor, sir, this is my thesis. I thank you, Lord.